May I pray before the Roshi?
Yes.
For listing a hearing matter of 2018,
Oh.
it is dismissal from service matter, my lord. It may be taken at next Thursday, my lord.
Next
Fourth.
Thursday?
Fourth, my lord.
When?
Hearing.
No, that is a motion week now. It has been declared a motion week. We'll have it after the 4 to 10 has been declared a motion week.
Yes, my lord. Then after Bihu, at that may be.
Yeah. 30 April.
Ma'am, please, Your Lordship. My lord, I beg to mention for listing a content matter after vacation, ma'am.
Okay.
Any day after 23rd, 24th,
Yeah, 29th.
29th.
Please, Your Lordship. Lordship, I beg to mention an I for implement, Your Lordship, after vacation.
26.
Lordship, may I pray for 29th, Your Lordship?
Okay, 29th.
Obliged.
May I please your lord, I'm listing for a contempt case, my lord. So matter may be tomorrow, my lord.
After view.
After before. Then another one is WPC, my lord. So
Same after view.
May I please, Lordship? Lordship, I beg to mention item number 7 for adjournment, Lordship. Lordship, let the matter be taken up after before, Lordship.
You are appearing on behalf of?
Mr. A.R. Bhuya, petitioner.
On request made on behalf of Mr. A. Bhuyan, then the council for the petition. Please, after 2 weeks.
Lordship. Highly pleasant.
Item 1 of daily admission.
Yes.
The Lordship, issue regarding age of superannuation of the petitioner, who is a professor in Amyo Kumar Das Institute, whether the age of superannuation will be 60 years or Lordship 65 years. That is the issues to be determined by your Lordship. And the government was directed to produce the record of the cabinet memorandum, whether that has been on record, my lord. Otherwise, issue is that, my lord, the denial is on the ground that the institute in which petitioner is working is not an educational institute, rather it's a research institute. And on the last occasion, my lord, my submission was that the distinction sought to be made by the state authorities on the basis of a educational institute and the research institute only to deny the enhanced age of superannuation, and which is arbitrary in nature in violates Article 14 of the Constitution. Because, my lord, research is essentially a part of education, and there is no statutory definition which defines educational institute that excludes research institutes from its purview. That is my lord submission.
Yes,
Today, my
have
lord,
you got your?
No, my lord, I have not received it yet, my lord. This Transformation and Development Department, they are not dealing with the cabinet decision. Cabinet memorandum is dealing with by the Human Political Department. They are not made party. And even higher education also necessary because he want to enhance his age to 60 to 65. He is deal with by the higher education. The non-joint necessary party also, my lord, petition may be dismissed. It is settled law. It is a admitted position that it is a research institute, not education institution. I will submit all these things.
let them argue, my lord, on the basis of record, Lordship will decide.
Yeah, but I want to see the cabinet memorandum.
Cabinet memorandum, my lord, I have not received. I have returned to it, my lord. But because Women Political Department, they are custodian of that.
So you write to them.
I have written one letter, but I haven't received any instruction.
So when can you get?
They say this is a informal. This is a lordship policy. The decision is a informal. That's why I'm like, there are two things is there in cabinet.
So no. Cabinet took a decision on 19/9/2022.
Yes.
Correct. On the basis of a cabinet memorandum submitted. I want to see that cabinet memorandum.
Actually, I wrote to the Women Political Department.
So how long will you take?
My lord, Again, I will have to send a reminder, my lord.
Lordship may direct the production of the cabinet memorandum otherwise, my lord. And so far as
Actually-
conjoinder of home and political, my
That
lord,
is the-
my grievance is not against home and political department nor against education department. So making them party,
Okay, whatever it is, let us see when you can get the.
Cabinet, my lord, what about the instruction they, my lord, they can provide it, my lord, I will have to wait for 1 week, my lord.
1 week,
1 week.
okay. But Mr.
each appropriate.
Internet Council for the petition.
And there is an amicus also. Man.
Who's the amicus? Yes, as well as Mr. Chakravarti. Learned amicus. On request made by Mr. TC Chutia, the senior governor, additional senior governor. 1 week time is allowed to enable him to produce the cabinet memorandum. in
Whatever
connection-
cabinet memorandum or whatever instruction, my lord, I don't know.
No,
Cabinet
cabinet
memorandum.
memorandum in connection with the cabinet decision taken on 19/9/2022.
2012.
My lord, lordship order may be, my lord, punished to me because I would provide it, my lord.
Yes.
22 no 19/9/2012.
19/9/2012, my lord. Cabinet memorandum.
19/9/2022, I think.
2012,
2012.
my lord.
12.
Okay, 19/9/2012. Cabinet decision.
Yes, my lord.
Where's the cabinet decision
My lord, we don't have the cabinet decision
Cabinet
yet,
decision,
but
we have annexed our affidavit, my lord.
in your affidavit?
page 74, my lord.
Page?
Page
78.
78, sorry, 78, my lord. It's a
Okay.
notification issued in pursuant to the cabinet memorandum, cabinet decision, my lord. Annexer 7.
19/9/2012.
Nineteen nine 2012, huh? Not 2022.
It is.
19/9/2012.
Notary grant.
For raising the age of retirement of all professors of educational institutions, including medical colleges, to 65 years. Stop. You want a date fixed?
Yes, ma'am.
Yes, sir. On 9th, my
List
lord.
or night will be difficult. We'll have it on
10th month.
23rd, 23rd, after Bihu.
After Bihu, my lord, I will not be available for last present, my lord. Right from, my lord, 20 to up to 29, I will not be available.
Then we'll have it on 30.
That will not matter, my lord.
Not 30.
18, my lord.
18th.
18, my on reopening.
Okay.
Oblige me.
Two and three.
Well, in this case, the argument was concluded. We are directed to submit written arguments. In fact, my friends have already submitted, so mine was being waited for. That I am filing to them.
We have already,
Taken to me.
on behalf of respondent number 7 already filed, madam.
All the
Yes.
parties have filed now.
Not the itinerary.
But Mr. B.D. Goswami, learned counsel for the petition. Also heard respondents 2 to 6,
Yeah, so IIT, madam.
Mr.
AB day.
A.B. Day, learned counsel for the respondents 2 to 6.
It
Your A.B. Day,
It was argued by my senior, Mr. R.P. Kakoti, my lord. My lord, may record.
Senior advocate,
Also-
Mr. R.P. Kakoti had approved.
R.B.
Kakoti.
Kapati, learned senior counsel, assisted by Mr.
AB day.
A.B. Day for the respondents 2 to 6. And Mr. D.J. Manda, learned
Number
senior
7,
counsel.
other matter, my lord. Item number 3, WPC 3937.
And Mr. D.J. Manda, learned senior counsel, assisted by MS. P.B. Das for the respondent number 7 in
3937.
WBC 3937 of 2022. Hearing complete.
Much obliged.
Four and five.
Please allow.
My lord, here is the case is the termination of the petitioner, my lord, who has been appointed. And there was engrossed, my lord, lordship, kindly have a look at page, my lord, where we have been appointed, my lord. That your lordship will see at page 24, my lord.
Yes.
Lordship, Mr. P. Naik appears for this matter, your lordship. Due to personal difficulty, could not be present today, your lordship. Agenda the matter for the day.
The same thing are happening, my lordship will see the orders, my lord. Like
Who's appearing in the other petition?
other also my senior counsel.
But Mr. J. Barbuya, the counsel for the petition. In WBC 5090 of 2021. As well as Mr. S. Katakuri, the counsel for the petition in WBC number 5310 of 1921. On request made on behalf of Mr. P. Nayak and Standing Council, GMC. When do you want?
Can it be on 23rd, my lord? It is a
23rd
Tuesday.
will not be there, your lordship. Would it be on 25th?
Okay, list on the fifth.
My lord, only one thing, my lord, handover to be made, my lord, to dispose of on that day.
Yes. An endeavor shall be made to dispose of this petition on the next week.
Hey, please, your lordship. Your lordship, my senior is on legs in court number 1, your lordship. Kindly pass over the matter for.
My lord, in this case, Mr. Chaudhary wanted to go through the records. I have got
DPC.
the records. So records I can produce. Because it's a case of denial of promotion. So Mr. Chaudhary wanted records of the DPC. So records of the proceedings of the DPC are very much with me. I can place it.
Let the matter be called after some time, your lordship.
After some time.
Deeply obliged.
If you have some difficulty, we can fix another day.
Let it be. I don't know because
After some time, your
after
lordship.
some time then.
It's your call.
Well, let it be on some other day in that case. If, when he will be free, nobody knows, then I may be engaged elsewhere. So let it be on some other day, if that be the case. Records I can very well place. I can hand over the records.
When do you want?
They may go through the records. Because then they will say that they have to peruse it.
After Bihu. After Bihu. It will open where you're after Bihu.
After Bihu, my
After Bihu.
On request made on behalf of
No,
Mr.
let records be with your lordship.
K. N. Chaudhary, then a senior counsel for the petition. Will list the matter of
Just a
on
minute.
19th, can you?
19th, your lordship.
19th will be difficult.
18th.
No, hearing
Not-
date.
not-
On 23rd, madam.
Yeah, 23rd.
Do we have a case?
So records you retain it, suppose
Very well. The records are with us.
it may be misplaced.
Records are with us. Very well.
Deeply obliged.
Lordship, pass over the matter for time being.
Why?
Lordship, Learned Counsel A. Sharma, he's on like Lordship.
The issue involved is promotion, my lord. The order by which, my lord, the promotion was finally denied, my lord. Yes,
Item 9.
Item 9.
Number 1.
Yes,
Yes. CGC,
my lord.
Last occasion, AST was appeared.
In fact, last occasion also she was absent and
no,
AZ was
last occasion, RK.
AZ was called, my lord, because the engaged counsel was absent. But then probably he is also not having copy. No, not notice. Notice, no admission. Reply file is available.
I'll inform the central council. It will fix another date on next.
Who's the central council?
S. Borwa, Miss S. Borwa.
Yes, Guru. Simantini Guru.
Simantini.
She is government council.
MS.
Yes.
S word. But Mr. P. Bhatak, Learned Counsel for the petition on request made on behalf of S. Barwa, Learned CGC. When do you want?
Next week, my lord.
Next week is a motion week.
After vacation.
After vacation, my lord.
24, 23 or 24, my lord.
25th.
20.
My lord. Deeply obliged.
10.
Yes,
Let my senior counsel start. My senior is coming.
how can you start? Yes, I can.
May it please the Lordship. In this case, the petitioner before Lordship is paying for retrospective promotion because he was denied his promotion on the basis of some uncommunicated adverse SCRs. The SCRs were communicated after the DPC was held. Yes, the DPC was held on 29/6/2010 and SCRs were communicated 29/6/2010, the DPC was declared. And the SCRs were communicated, my lord, on 8/7/2010.
Yes.
8/7/2010. So, my lord, these SCRs are related to, my lord, 2005/6 and 6/7. In number of cases, my lord, this honorable court as well as, my lord, the honorable apex court has held that, my lord, uncommunicated adverse SCRs cannot be taken into consideration while considering a case for promotion. On that very ground, lordship can dispose of this petition without going into the merits of the case.
What are they saying in the affidavit?
They say, my lord, prior to 2010, there was no provision for communicating the SCRs. That is their stand. And after the decision of the Devdutt, they took a decision for communication of all the SCRs, and accordingly, SCRs were communicated to the petitioner. That is their stand. But, my lord, that stand cannot, my lord, stand before the, my lord, a decision taken by this honorable court as well as by the apex court, my lord, in number of cases. I will rely on those decisions also, my lord. If my friend agrees, then, my lord, lordship can dispose of the matter, my lord, without going into the merits also.
What do you say, Gupta?
My lord. Lord, in this matter, my lord, there are two things, my lord. Adverse entry is a different thing, my lord. What is agitated here is, my lord, the below benchmark grading.
Below benchmark is also an adverse criteria.
No, my lord, there are two different things, my lord, because so far as adverse entries in the ACR is concerned, that was settled, my lord, it has to be communicated. But, my lord, below benchmark grading, my lord, that was started only after 13/4/2010 notification by the my lord, Ministry of PPG, my lord. It was only after 13/4 that the disclosure of below benchmark grading in ACRs were required to be communicated to the petitioner, my lord. Here, my lord, this is a second round of litigation, my lord. Earlier, the petitioner approached, and, my lord, at page 141, on the same cause of action, my lord. Page 148 is the operative portion. So the direction was given to, my lord, reconsider the case and pass, my lord, consequential paragraph 11, my lord, page 141 at the bottom. Therefore, upon due consideration of the case in its entirety, I am of the considered view that the respondent authority concerned should revisit the grievances projected by the petitioner through his representation dated 27/2010 and 33/2011 in particular. Such examination should be initiated and completed as expeditiously as possible, preferably within the outer limit of 6 weeks from the date of receipt of certified copy of this order. It is needless to mention herein that in the event of such an examination, the competent authority is of the view that the grading of the
ACR of the petitioner for the period and the consideration requires to be upgraded, the petitioner will be entitled to all consequential benefits flowing out of such decision. So, my lord, so far as the fact of non-communication, it was already agitated, my lord, in the earlier round of litigation, and the direction was given to the authorities to consider whether, my lord, the grading in the ACR could be upgraded. Now, that was considered subsequently, and the authorities took a fresh decision at page 149 pursuant to the order by the Honorable Court, my lord. Paragraph 2, page 149. Pankaj Dixit is hereby informed that the issue,
I've seen that.
my lord, have been given due consideration, who has concluded and directed that no new points have been noticed on the issue and the case is devoid of any merit. So, my lord, the fact of non-communication was already addressed in the earlier round of litigation, and after due consideration, my lord, the court has given a direction to the authorities to consider the fact whether the gradings could be upgraded. And accordingly, my lord, the authorities revisited the entire ACR, my lord, and came to this conclusion that it cannot be. So the fact remains the same that on the matter of record, my lord, he is below the benchmark.
Then we'll hear on merits.
Well,
Are you ready today?
yes,
I prepared a written argument as well as the compilation of judgments. Two loose judgments I have given, the others are compiled.
Yes. Proceed.
My lord, the petitioner before lawsuit, my lord, he was appointed as assistant executive engineer on 18/5/2002.
Where is that?
18/5/2002, my lord, he was appointed. That lord, you will find at page 24, my lord. After clearing the engineering service examination held
18/4.
18/4/2002.
Not executive engineer, assistant
It's the
executive.
assistant executive engineer. Next, I'm praying for promotion to the post of executive engineer. He was appointed as assistant executive engineer. That is first entry in the service. Malad, his promotion was due and the DPC was held on 29/6/2010. And SCR's reckonable for the purpose of promotion starts from 2005/6. And the
Is it a 3 years SEO or 2 years?
5 years, basically. 5 preceding years.
Oh.
Out of 5, ACRs, my lord, he was 2004/5, he was very good. 5/6 average, 6/7 average,
1 minute. 2000.
4/5,
Oh.
part very good and part good. 4/5. 5/6 below benchmark, that is average. 6/7 average. 7/8 becomes very good. 8/9 good. These are the ACRs reckonable for the purpose of promotion. These two ACRs, my lord, before proceeding, my lord, the benchmark for promotion to the post of executive engineer is good. And average is malad below good. That is as
It's good.
benchmark is good. So, malad, as my friend says, that prior to 2010, there was no provision for communicating the ACRs. That is not the fact. Malad, below benchmark ACRs were always to be communicated, even prior to Devdutt. Devdutt came, Devdutt, malad, the Honorable Apex Court held that all the ACRs should be communicated to the malad government servant so that they can know about their performance. For if there is any lacuna, they can enhance their performance. Only from Devdutt, malad, in the case of Devdutt, malad, even the good ACRs were also directed to be communicated, even the very good also. Prior to that, the average is a malad below benchmark grading. That was always to be communicated, malad. That was, there is no bar prior to Devdutt, malad, for communicating the below benchmark ACRs. They have their own guideline. So, malad, the stand taken by the
Where is the guideline?
malad,
Guideline.
guideline, I'll take a loss to the malad page 20 from 28. It starts the guidelines, malad. This is malad compilation of various office memorandums, malad, DOPT guidelines published by the respondent department, malad, the DOPT. It starts from page 28, madam.
Relevant portion.
My lord, column 1.1, page 29, my lord.
Yes.
1.4, 1.5.
Read it.
My lord, the performance of government is ultimately the sum total of the performances of the individuals through which it functions. Government has therefore to know from time to time how its constituents function. The information is essential for proper personnel administration and management. It is in the interest of every government servant that he should know how well or otherwise he is performing his job. Without this feedback information, it will be difficult for him to plan his career development in a systematic manner. In fact, he would be more interested in knowing his defects. His defects would affect his career advancement in the long run, unless he comes to know of them in time and overcomes them by taking special efforts. The immediate superior officer of a government servant, who is the reporting officer, in the matter of writing his assessment report, should be vitally concerned in writing the annual performance assessment report of every one of his subordinate in an objective and impartial manner. As the superior officer functions through its subordinates, he also gets credit for the good work done by them. It would be, therefore, be in the interest of reporting officer himself to assess the performance of the subordinates objectively and thereby give them counseling and proper guidance for improvement of their performance. So, my lord, clause 1.3 mandates that performance counseling is necessary for improvement of the subordinate officers by the reporting officer. The system of APR on performance of government servant is a means to an end and not an end in itself. The ultimate goal is to optimize the achievement of the government policies and programs. This is possible only if the APAR lead to optimization of the performance of the concerned government servant. The main focus of reporting officers should therefore be developmental rather than judgmental. APAR should be a true indicator of the achievement of the government servant. It should not be mere tool to control or discipline him. The system of APAR has two principal objectives, and the reporting officer should have a very clear perception of these objectives. The first and foremost is to improve the performance of the subordinate in his present job. The second objective is to assess the potentialities of the subordinate and prepare him through appropriate feedback and guidance for future possible opportunities in his service.
See, no need to read all this, read the relevant portion of it.
My lord. Now the page 30, page 32.2, how ACR is to be initiated, my lord. The reporting officer at the beginning of the year has to set quantitative physical targets in consultation with each of the government servants whose reports he is required to write. Performance appraisal is meant to be a joint exercise between government servant reported upon and the reporting officer. While fixing the targets, priority should be assigned item-wise, taking into consideration the nature of and the area of work. The APR is initiated by the government servant to be reported upon himself. Roshni, kindly turn to page 38, chapter 5, my lord. Timely completion of annual performance assessment.
Hmm.
The annual performance assessment report are vital for proper personal administration. It is essential that they are completed within a time frame so that up-to-date annual performance assessment reports are available at a given time. With this end in view, the time schedule has been prescribed. And time schedule has been prescribed in Annexure 3. Annexure 3, also you'll find.
No, that's a different thing.
My lord, they have to, my lord, communicate the ACR within a period of 1 month from the date of reporting. From the date of reporting.
Where's that? Where's that?
Yes, my lord, I'll take it to my lord. This is Annexure 3, page 47.
Page?
47, my lord. Column 6, my lord. Disclosure to the officer reported upon where there is no accepting authority. 1st September. Reviewing authority has to, my lord, submit his report within 30th June.
This guideline was issued which year?
My lord, this is compilation of, my lord, 1985.
Where do I get that?
My lord, page 38, my lord. Page 38, my lord, 5.1, below loss will find the DOPT guideline, my lord. And date, 23rd September 1985.
You have a copy of this OM?
This copy I do not have, my lord, but this is
Gupta, do you have a copy of this?
equal contents to equal guideline about this.
I'm not having it, my lord. I think this will have some relevance.
But the issue is here, my lord, whether the communication is necessary or not, my lord, but
So that is why,
my lord.
in terms of this OM,
Page 38.
page 38, and then the relevant portion is at
47.
page 47, at column number 6, serial number 6, which says disclosure has to be made to the officer reported by 1st December if there's no accepting authority. If there's an accepting authority by 15th of September. So this is in terms of this OM dated 23rd September 1985.
No.
Let us have a look at this OM. I think you'll be the best person to produce this
Well,
OM. But Mr. I.S.
will produce
Saikya, Learned Counsel for the petition. Mr. H. Gupta, Learned CGC, shall produce a copy of the OM number 35014/4/83 stock A dated 23rd September 1985, issued by the Ministry of Personnel and Training, Administrative Reforms and Public Grievances and Pensions. You'll take some time?
My lord,
How long?
week's time we'll do, my lord.
Is the matter? After 1 week?
My lord, but on 25th, my lord.
Okay, is the matter on? Okay, we'll have it on 25th?
My lord. I think the matter parted, my lord.
No, not yet. We've not even gone deep into it.
My lord.
Anyway, I'm keeping this on the file.
My lord.
I'm keeping this on the file.
My lord. Publish.
My lord, my senior is coming. She is another court, so it may be past our time. being-
May please, your Lordship. Lordship, in this case, Lordship, my senior counsel, HLS Chaudhary is out of station due to election, my lord. It may be fixed, my lord, in the month of May, second week of May, my lord.
Month of May, I think it will be better June, my lord. Senior is contesting election, my lord, so he'll be busy.
Election over in the April, 26th of April, my lord.
My lord, I have no problem, my lord. We have filed our affidavit.
Okay, on request made on behalf of Mr. H.R.A. Chaudhary, then it's new counsel for the. When do you want? May?
Second week of May, my lord.
Is the matter on 7th May?
Seventh, election was in Guwahati. After 7, election was in Guwahati.
My lord, second week, if he wants, there is another election day.
Election in
That is
Guwahati.
why I said, my lord, let it come after June, my lord. June 4th.
Third week of May, my lord.
16th,
Published.
16th.
Published. My lord, the interview is there, my lord. Interview will continue.
Interim order procedure.
Published.
Till the next.
Published.
13th.
May I please, your Lordship? Lordship, in this case, the petitioner earlier approached before this honorable court by filing a writ petition seeking mandamus, and that writ petition was disposed of by this honorable court on initially 19/5/2023. Immediately after this judgment of this honorable court, and the respondent authority has Lordship appointed the private respondent against the single vacant post. Thereafter, the writ petitioner again approached before this honorable court, and this writ petition was disposed of by this honorable court on 8/8/2023 to consider the case of the petitioner in terms of the direction passed by this honorable court in the earlier writ petition. And Lordships, though the respondent was duly represented by their learned counsel in this first writ petition, Lordship, but they have intentionally violated the direction of this honorable court and filled up the single vacant post. And now they're coming to the stand with Lordship 8/9/2023 by passing a speaking order, which clearly indicates that it is an intentional violation from the part of the respondent authorities, Lordship. And my humble prayer in this writ petition is that since there is a direction from this honorable court to consider the case of the petitioner against the single vacant post, and considering that my length of service is limited, Lordship, because I am going to retire and already retired on 31st of January 2024. Sorry, 31st of December 2023. Lordship, only my humble submission is that at this point of time, Lordship, notional benefit that may be considered in this writ petition, Lordship.
Who is on the other side?
I just came to know that. Here is the federal government has to give. I think. I would like to request management to provide me a copy of the resolution copy.
That I can provide, but the situation is that though the petitioner Lordship retired from service on 31st December 2023, but service book of the petitioner is under the possession of the Lordship learned government council Lordship. That's why Lordship in fact he cannot process for his retirement benefit Lordship. That may be directed to release immediately Lordship.
So do you have a copy of, do you have a service book?
Original service book Lordship.
You are applying for the?
For the government. Otherwise, perhaps from by looking at this reduction, perhaps because it relates to the treasury, so finance will be also necessary.
Finance is a party.
Under the employment is done by the deputy commissioner for the government.
Since I understand, provide me a copy of the deputation, I'll get the instruction.
That I have no difficulty to furnish the copy of the writ petition, but the situation is that unless and until Lordship the original service of book of the writ petitioner will not return to the authority Lordship, there his retirement benefit that cannot be processed by the authority Lordship. That is the main problem Lordship.
Problem is he doesn't have the brief. Come to the mic.
Let me get the instructions, Your Lordship, on this issue. If he provides me with the writ petition copy, let me get the instructions as to what is the current situation.
The only issue is he has retired in December. Okay. At least his pensioning benefits he has to get.
Yes.
Whether there's a litigation going on or not, that's a different issue. So if you have the service book, you return it back. I cannot give a direction directing you to return it back because since you don't have the brief, you don't know whether you have the service book.
Yes. I have to get the instructions, Your Lordship.
Day after tomorrow Lordship?
No, day after tomorrow, not.
Because Lordship, this is a matter of service book Lordship, because he retired on the 31st December Lordship.
After Bihu, Your Lordship.
31st December Lordship, he is waiting for the service book.
But
Lordship.
Mr.
D. Sharma Lordship.
D. Sharma, Learned Counsel for the on request made by Mr.
D. Bora.
D. Bora, Learned Government Advocate. For the response number 4. List the matter on, when do you want?
Your Lordship, on 23rd or 24th. 24th of April, Your Lordship. After Bihu, Your Lordship.
24th April. Mr. S. K. Mehdi, Learned Counsel, Learned Standing Counsel, Accounting General. Appears for the response number 2.
Lordship, that observation may be made Lordship, otherwise if
Since he does not have the report, I cannot make an observation.
Yeah.
Once he brings the record, then we can direct him to, we'll see up on 23rd what happens.
Yes, Lord. Highly blessed.
You furnish him a copy.
Yes, Lord. Today itself.
14.
Yes,
Lordship, name of the council may be directed to reflect in the postage Lordship, because in next occasion, again, Lordship, another council will come Lordship.
The Lordship,
Problem will be.
I may not be here because of the roster.
Lordship, this is the type.
Because of our
technical
roster
problem that is
system,
happening, Lordship.
I may not be here to assign this particular court. Your Lordship.
Again, Lordship, another
GA
council
Assam
will come
being
again and
Lordship,
ask.
GA
GA Assam is already there.
GA Assam.
GA Assam is already there. There's no point of this.
Lordship, but the thing is that.
There's no point of giving a direction to release the particular council. They're all
But-
government advocates.
But the situation is that in the last occasion, Lordship, the another council was represented, he possessed the entire reports. Lordship.
Let's see.
I'll inquire.
Lordship, in item number 14, Mr. D. Nath, Senior Government Advocate, he is appearing in the matter. Otherwise, my lord, pleadings are complete in the matter. Let the matter be fixed at 2, considering the urgency, my lord. He is on legs, my lord, in court number 1.
At 2 years, Lordship.
Obliged.
15, hearing, order, my lord.
But on the last occasion, the respondents were directed to obtain the instructions as to whether the suspension was revoked, my lord.
Where's DC Chutia? Mr. Dar?
15, 1 5.
1 5. If he took place here, my lord, he's in another court, my lord. I'll just inform him, my lord.
After some time, my lord.
16.
My lord, due to some personal problem, Engaged Counsel Emerson is unable to appear in the court.
This
Therefore-
judgment, this matter is already been covered. A similar issue and already a single learned court has dealt with. A similar order can be passed. Similar issues, similar facts, similar.
But then is,
I understand. Even the last time, the last order also, my lord may check. I given them a copy. That's of 2022. The matter has been kept pending after then also. Even served a copy of the judgment. Same facts, same circumstances, everything is same. So my lord may give a date and may.
Okay, on request made on behalf of Mr.
Wadud. Abdul Wadud.
Who's the counsel, engaged counsel?
Engaged Emerson.
M. Hussain, then counsel for the petition. List when?
It is
When do you want?
after 1 week.
After,
All of my name may be recorded.
Mr.
SP Sharma,
SP Sharma, Learned Standing Counsel,
APDC.
appears for the APTC.
No, the date may be fixed, the matter can be disposed of. After Bihu vacation.
29th.
29. That's all I know.
17. Seventeen.
On appears for the petition. List after 2 weeks.
Eighteen.
Please, your lordship.
May I please, your lordship, may I kindly pass over the matter for the time being? Mr. Sharma is like free for another. Deep your pleasure.
Nineteen.
But very well for the petitioner, the main contesting respondent is FCI, and they had filed an application for early hearing. Perhaps the counsel for FCI is not present. And the matter involves, my lord, the record of the disciplinary proceeding, the domestic departmental inquiry will be required. Because
You are appearing for the FCI?
no, he is for the
I am
state
for
of
state of
Arunachal.
Arunachal.
I'm also led by a senior counsel. My lord. The thing is, the petitioner was on deputation and then to FCI, then inquiry was initiated, but before commencement of the inquiry, she was repatriated to the parent department. So the subject matter of the writ petition is the departmental inquiry, the proceedings of inquiry, and the holding of a common inquiry, as well as the right of the borrowing department to go ahead with the inquiry, my lord. So
Where's the
the
FCI?
FCI, and they have also filed an early hearing petition also.
They file early hearing, they don't appear. Wow, what can we do?
In that case, Lordship, fix another date with the direction to
What,
FCI.
Mr. Das Gupta? No, senior counsel assisted by Mr. S. Chakravarti.
Right.
Counsel. Mr.
A. Chandran, Lordship.
A. Chandran Leonard,
Additional senior governor.
additional senior governor advocate, appears for the
5, 6,
respondents 1 to 4,
5, 6, 7.
5, 6, and 7. You are appearing for the FCI?
My lord,
Yes. Okay, cancel the order.
I'm ready.
Record will be recorded.
You have the records.
Yes, I have the, record to,
Of original disciplinary proceeding because
I don't think it was called for.
definitely.
I will then
Okay,
need
heard
time.
Mr. Das Gupta, then a senior counsel assisted by Mr. S. Chakravarti, then counsel for the petition. Mr.
BK Signal,
BK Singh, Leonard, standing counsel FCI
FCM.
shall produce the records of the disciplinary proceeding by the next day. Stop. Mr. A. Chandran, Leonard,
Additional senior.
additional senior governor advocate appears for the respondents
5, 6, and 7.
5, 6, and 7. List down, when do you want? When can you?
My lord, on 3rd of May.
Third of third. Let it be on 7th.
7 is the election day.
Oh, election day.
Then 14 May.
14th May. 14th.
14.
With judgment the page. 2021 as well.
Very pleasant. My lord, these three matters are analogous, my lord. Same issue, my lord, regularization. So far, my lord, some employees are regularized, my lord. And this petitioner in item number 20, he is serving in the department under the corporation since 24 to 1995. Until now, my lord, he has been treated as temporary employment, not a regularization.
How were you appointed?
Yes, my lord, that is right. My lord,
On request, temporary basis. On request by the union,
no.
on temporary basis, he was appointed for 45 days.
Initially,
Lots.
if your lordship will
This is
come
how he was
to,
appointed. And lordship knows Uma Devi's judgment, High Court judgment, Open Decca judgment is there. Regularization is not a matter of right. You cannot claim regulation as such because of the length of services. You cannot claim that. These are all ultimately public posts to be filled by public employment through competition. Maybe some weightage may go to him. That is a different case altogether by the recruitment agency. They may do it. But directly regularization, they cannot.
if my learned friend is saying that, my lord, then he should also point out, my lord, I have filed an affidavit. The parity position, my lord, the division bench judgment is there, my lord.
Which affidavit?
Your lordship will consider page 83. Before going to merit, my lord, page 83. The judgment of similar person, my lord, have been regularized. Page 83, I have filed in an affidavit annexing that judgment, my lord. Page 88, your lordship will see. May I read it, my lord? Paragraph 3, my lord. Page 84. Subsequently, this read
Para 3,
para 3 of page 84.
84.
Yes.
Yes.
Yes. That the petitioner states that
On the above subject matter mentioned in paragraph 2 of the instant affidavit, it could be known that the above incumbent in read appeal number 6/2019 sought for regularization of his service with a claim to clear all the area salaries and allowances from the respondent corporation. And accordingly, in the above judgment, the division bench of this Honorable High Court by judgment and order dated 26/7/2022 allowed the writ appeal on contest and directed the respondent authority in IOCL Assam Oil Division to regularize the service of the said incumbent along with benefit accrued thereof be given to the said incumbent. In the above judgment, absorption of the said incumbent writ appellant, the Lordship will notice this, is similar to the present absorption of the petitioner on less than 45-day basis. And the treatment of the temporary engagement given to the petitioner by the corporation eventually after this judgment is a clear discrimination without any reason and without any fault, and thereby the action of the part of the respondent is violative of the Article 14 and 16 of the Constitution, in which case the case of the petitioner is also applicable by the above judgment passed in writ appeal so and so. Next paragraph, my lord, that the petitioner states that pursuant to the above judgment and order passed in writ appeal so and so by the Honorable High Court, the respondent IOCL AOD Digboy Refinery have regularized the service of the said incumbent oblique writ appellant with all area service benefits. File is later dated 16/12 issued by the concerned respondent of the corporation.
Where's this letter?
This letter is, my lord, with the corporation, my lord.
You have a copy of this letter?
No, Lord.
And I can also procure, my lord, that letter is there, my lord.
Let us
Because
see that letter.
I have to take instructions whether they are exactly similarly placed with these people. Because
No.
there has been number of recruitments taking place in IOC from all various quarters. Somewhere pursuant to an advertisement, somewhere pursuant to some vacant post in there. I do not know exactly how these people stand. My
No.
instruction is that these were all temporary posts. I can just place a document also. It was a request made by the Union of India, by their worker union for engaging them. And that particular request was accepted. That cannot be a mode of regular selection of people on request. So that is a document that I am holding with me. I can place that document to indicate. But what he's trying to do is he's trying to equate himself with some other. So I need to exactly verify whether they are identically placed or not. And if there's one wrong, the two wrongs cannot make a right. So
How much time do you require?
10 days time loss.
well, kindly may I page 95 of this judgment copy, my lord, read appeal, paragraph 14. my lord. I was also appointed on compassionate appointment as per the respondent affidavit. my lord. And this,
You are appointed on compassionate.
yes, because my after the expiry of father who was serving in the corporation, they absorbed me. Now, only thing is that they are treating me as temporary employee. That is the case.
Lordship,
Which
we
is-
also see page 20 of our affidavit, where the document, that official document is there, how they were appointed.
I will
Page
come to
20
that,
of the
my lord.
affidavit.
Paragraph 14. my
Anyway,
lord.
since he wants to take
Yes,
some
yes,
time.
I need to.
Well,
put
only
some
thing is
clarification
that,
on
my
this.
lord, in item 22, my lord, this person has only 1.5 year in service left.
That will see.
10
That
days
is-
time up.
Only date
he's
may
asking
fix.
for not.
Yes.
even 10 days.
Let me also have the original record. That is also not with me. There,
Okay, heard Mr.
B. Borua.
B. Barua, learned counsel for the petitioner. On request made by Mr. A. Sharma,
yes, Lordship.
learned standing counsel,
Produce that.
IOC,
Lordship may say to produce that document
list the matter on, when do you want 10 days
after
time?
10 days, any day
Well,
after 10 days.
may I pray, my lord, 25th, my lord, April after due vacation
Yes, yes.
On 25th April.
for hearing.
Stop. The standing council IOC shall produce the records
Record, yes.
as well as
The selection process insofar as the petitioners are concerned.
No, the regularization of that employee, my lord.
That also I'll produce
The
everything.
order of regulation.
as well as the
Letter dated 16/12.
letter dated
16/12/22. Paragraph 4, my lord.
16/12/2022,
In read appeal number 6.
by which the appellants in writ appeal number 6 of 2019 were regularized.
Yes,
by giving them all area service benefits.
yes.
That I will produce, but whether they are also in the same footing For that, I need to see the records.
That reflected.
Yes, some people may have been regularized. Their entry may be different.
Obliged.
23.
I am appealing for the respondent, my lord. Affidavits have been filed, my lord.
Readings all complete.
Everything is done. They have filed reply also, my lord.
None appears for the petition. Mr. BK Das, Leonard.
For the respondent.
Council appears for the response. Please, Dr. Hurwitz.
I can vote 15, my lord. I was told, my lord. I can vote 15.
You've got the instructions?
Yes. Instruction was, my lord, whether he was under suspension at the time of discharge or not. Yes, he was under. That is the answer.
Where's the instruction?
This one, my lord. Second paragraph, my lord. Subsequently, departmental proceeding was initiated against the Dharmendra Guru, and he did not submit his reply to the first focus notice in spite of 4 reminders served to him. As the petitioner was not willing to appear before the inquiry officer submitted the findings of the DP as expertise, and the petitioner was discharged from service with effect from 13/12 to 2017 during his suspension period. He was under suspension. Because he did not reply, he did not come cooperate. That's why expertise whatever inquiry was done. And newspaper also, it was published in the newspaper.
The fact remains, my lord, is that uh, the the disciplinary proceeding which was initiated against the petitioner, that is the was the rules, my lord. Because the judgments which have cited on the earlier occasion, it clearly shows that the witnesses they were to be examined, my lord.
Let us see your case.
The first inquiry report is at page 27, my lord.
No, page 19 is your show cause notice.
Show cause notice, my lord.
On the section 65.
So,
Assam
of the
Police.
Assam Police, Red Week 66 of the Assam Police manual, my lord.
You have a copy of this?
I have this, so cause I have an next, my lord.
No, copy of the Assam Police Act?
I have the Assam Police manual with me, my lord. The police act was also there.
Assam Police Act 2007, Red with 66 of Assam Police Manual Part 3. Article 311.
So, my lord, after that, my lord, notice was issued.
Let us have a look at this.
Yes, sir.
Assam Police Manual.
Manual Part 3.
Rule 66, my lord.
Rule 66.
It says, my lord,
Page.
my volume is VK Devans, page 435, 66.
1 minute. Rule 66. Page?
Mine is
You're on which book?
VKD one,
I'm on.
435, page 435, mine. It says proceedings to be drawn up in case of major punishment, my lord. The major penalty is dismissal, my lord. A. B is removal. C is compulsory retirement. D. Reduction in lower service grade or post. E is recovery from pay. F is black mark. G is withholding of increments. And H is censure. So there is no discharge under the major punishment, my lord. In the present case, my lord, the petitioner was discharged from service. He was neither removed nor he was dismissed, my lord. He was discharged from service.
And this section 65,
65, my lord.
Police Act.
It's not there in my volume, my lord. I'll just check online, my lord.
Assam Police Act is there.
In my volume, it's not there, my lord.
You have page 1517.
15. No, this is, I think, the earlier volume, my lord, edition. Mine is still page old edition. 14.
Okay, proceed.
Then, my lord, after that, my lord, the inquiry report was submitted, my lord.
So after the show cause notice, did you make your reply?
No, my lord, there was no reply. There was no reply, my lord. Then there was a reminder notices which were issued. Thereafter, my lord, he was placed under suspension at page 26, my lord. On 14/12/2015, my lord. Then, my lord, the inquiry report was submitted at page 27, my lord. 9th of January 2017, my lord. The relevant part in the inquiry report, my lord, is at page 28. Wherein it states just before the findings, my lord, wherein it states, my lord, that thus in keeping with the above, the examination of the delinquent and the prosecution witnesses, as well as cross-examination and recording of their statements could not be taken by the undersigned, my lord. So the witnesses could not be examined, my lord. And thereafter, there was a finding to the effect that the delinquent was refused to appear. And accordingly, it was, there was a finding that it was sent to the commandant, my lord.
Where that you refused to appear?
At page 29, my lord. So, second last paragraph, it says, thus in view of the facts and reasons stated herein above, it is evident that the charges of gross misconduct for unauthorized absence and insubordination by willful neglect of lawful duties, lawful orders is established beyond doubt, against the delinquent so and so. Thus, as seen from the above fact, the delinquent has refused to appear before the undersigned for examination and recording of statement and cross-examination, if any. And in keeping with the orders received from the commandant so and so, I am submitting the report on inquiry cause against so and so in connection with DP number so and so ex parte.
So on one side, you did not appear at all.
He did not participate,
I
he
did
did
not-
not appear, did not cooperate. Then what to do?
But then, my lord, if that be the case, my lord, then it could not have been, there could not have been a finding to that effect that it has been established beyond doubt because the witnesses were not examined, my lord. They could have examined the witnesses, my lord. And Rup Singh Negi case, my lord, says that the witnesses have to be examined, my lord. The judgment which had cited on the earlier occasion. The witnesses were not examined. And the root of the matter is, my lord, as per the police manual, my lord, there is no concept of discharge.
Where's the impugned order?
The impugned order, the discharge order, which was a sale, is at page 32, my lord. 33 is the operative part. Under the circumstances and keeping all the above views, I being the disciplinary authority and due application of mine, came to the conclusion that constable number so and so is discharged from service with immediate effect from 13/2/2017. He should not be paid anything else whatever he has been paid earlier. So he was discharged, my lord. And under the police manual, my lord, there is no concept of discharge, my lord. And there is a judgment of this honorable court, my lord, in Babul Hussain case. That judgment has also been furnished, my lord. Wherein in a similar situation case, my lord, of the police department, he was also discharged, my lord. And thereafter, my lord, this honorable court has held that there is no concept of discharge, my lord. Babul Hussain, my lord, WPC 1136 of 2013, my lord. And the entire my lord has a copy of it again. Yes, ma'am. My learned senior had appeared on behalf of the government, my lord, in that case. And the honorable court at paragraph 32 directed for reinstatement of the petitioner in that case, my lord. Paragraph 31, be that as it may, this court is of the view that even if the inquiry is held to be in accordance with law, acting on the same by the disciplinary authority before giving a reasonable opportunity to the petitioner to submit his reply to the said report is not accordance with law, and accordingly the same is interfered with. Thus, this court also finds that discharge not being one of the prescribed penalties cannot be imposed on an employee under rules of 1964. Accordingly, the impugned penalty of discharge dated so and so is interfered with and set aside. Consequently, the order dated so and so is of rejection of departmental appeal also set aside. The petitioner in the present case stands on a similar footing, my lord. So in that view of the matter, I pray for allowing of the repetition, my lord.
So, my lord, remand back, it, my lord, ultimate set aside, there, no discharge is there, no board is there. Nomenclature said discharge is not there. It should be dismissed, otherwise, my lord, to remove like that. This is not, it is admitted fact. But lordship, set aside it, my lord, remand back to the text, my lord, because his absence is unfortunate absence is very difficult to understand in the police department. The police force, disciplinary force, but unfortunate absence is very difficult. It's dangerous also, my lord, for a department.
But in that case also, in this case also, though he was directed to be reinstated, my lord, however, taking into consideration the seriousness of charges, the authorities, if so advised, may proceed with the stage of issuing. In this case also, my lord, they can go ahead, my lord.
That's why I'm saying.
It may be, he may be reinstated, my lord, because I stand also on a similar.
You will be reinstated on suspension.
He was suspended, not reinstated.
Reinstated in service,
Yeah.
however, taking into consideration seriousness of charge, the authorities, if so advised, may proceed from the stage of issuing of second so cause notice, my lord.
Main problem was that he did not cooperate it, my lord, he in subordination to the higher authority, my lord. Had it been incorporated, otherwise it would be in different proceedings. The only discharge word that is malot or the interfered petition.
See, discharge, that is one thing. The disciplinary report, the inquiry report also indicates that no witnesses were examined.
It is a main
So
equity.
how would you prove your documents?
Malot, main equity is not present, malot.
Main accused is not present, but the prosecution was there. Prosecution witness was also not examined.
They could have examined the malot.
They could have examined the prosecution witnesses to prove the documents.
Yes, malot.
That was also not done.
Not done.
So everything has to go.
Yes, that's why malot, let him malot, start a fresh malot, set aside this malot order. I'm not malot opposing it because malot discharge word is not there, malot. That's why we set aside and let them start malot fresh
Disciplinary
disciplinary
proceeding.
proceeding.
If so
As per law,
advised.
as per law, yes, malot. And petitioner is directed to cooperate, malot.
He will cooperate, my lord.
Main thing is he did not cooperate. Simple order.
But Mr. S. Counsel and the counsel for the petition. As well as Mr. DC. Then an additional senior government. Appearing on behalf of all respondents.
All as per law.
On all the respondents. Stop. You are appointed as
I was appointed as my lord, constable, my lord.
did not enclose your appointment order.
No, my lord, that is. I was appointed as constable, my lord.
The petitioner, while serving as constable in the Assam Commando
Battalion.
Battalion of the Assam Police Service, able leave for 8 days, able casual leave for 8 days with effect from 1/9/2015 to 11/9/2015. Stop. However, after the expiry of the casual leave period, the petitioner did not join back to his service. And accordingly, a show cause notice dated 28 December 2015 was issued to the petitioner under section 65 of the Assam Police Act 2007, read with rule 66 of Assam Police Manual, part Roman 3, and article 311 of the Constitution of India. Stop. The petitioner did not reply to the said show cause notice. Accordingly, a reminder notice was issued on, what date is this? 11th,
11/2/2016, my lord.
11/2/2016.
4 times. 4 times.
What is there? A reminder notice? 11/2/2016 was issued to the petitioner to reply to the first show cause notice dated 28 December 2015. Stop. Another reminder notice dated 12/10/2016 was also issued to the petitioner, indicating that a departmental proceeding has been initiated against the petitioner and was initiated against the petitioner, and the petitioner was directed to appear before the inquiry officer on 21/10/2016. Stop. Drafted by an order dated 14/12/2015. The petitioner was placed under suspension with effect from 11/12/2015 for his unauthorized overstaying leave with effect from 12/9/2015. Stop. As the petitioner did not appear before the departmental proceeding, the departmental proceeding proceeded ex parte against the petitioner. And after conclusion of the departmental inquiry, the inquiry report was submitted by the inquiry officer on 9/1/2017. Stop. Vara. Consequent to the inquiry report dated 9/1/2017, the disciplinary authority issued the order dated 13/2/2017, by which the petitioner was discharged from service with effect from 13/2/2017, with a further direction that he should not be paid anything else, whatever he has been paid earlier. Stop. Para. You filed any appeal?
Yes, I had filed an appeal, my lord. Appeal I had filed, my lord.
Being aggrieved with the order dated 13/2/2017, the petitioner filed an appeal before the Deputy Inspector General of Police
On 6/11/2019.
on 6/11/2019.
19.
Where is that?
The appeal is at page 34, my lord.
No, the date.
Date, my lord, is in the list of dates, my lord.
Appeal is disposed.
Appeal was disposed, my lord, 23/9/2020.
Where is that?
That is at page 50.
The appeal filed by the petitioner was also disposed by order dated 23/9/2020. On the ground that the appeal petition is time barred, correct?
Yes, ma'am.
Stop. Being agreed, petitioners before this court by way of compulsion with petition. Stop. Para. Mr. S. Count learned counsel for the petition submits that under the Assam Police Manual, particularly Rule 66. There's no
There is no penalty of discharge, my lord.
penalty of discharge from service. And therefore, on this ground alone, the impugned order dated 13/2/2017 should be set aside and quashed. Stop. Drawing the attention of this court to the inquiry report dated 9/1/2017. Learned counsel for the petition also submits that the prosecution with witnesses that the evidence of the prosecution witnesses were not taken. And therefore, in the absence of such with, in the absence of such recording of statements of the prosecution witness, the, the, the documents produced by the prosecution could not have been proved, and therefore the inquiry report also stands vitiated. Stop. Practically, that is it.
Yes.
Para. Mr. T.C. Chutia, learned additional senior government advocate, in his usual fairness, submits that there's no provision of discharge in the Assam Police manual, and therefore the respondents may be allowed to have a fresh inquiry within a specific period of time. Stop. Para. I have considered the submissions forwarded by the learning council for the parties. Para. A perusal of the inquiry report dated 9/1/2017 clearly indicates that the delinquent officer and the prosecution witnesses, as well as cross-examination and recording of statements, could not be taken by the inquiry officer. So, this is apparent on the face of the inquiry report at page 28 of the present. Stop. What this court has noticed is also that the petitioner did not participate in the disciplinary proceeding, despite several notices being issued to him. Stop. Para. In the case of Rup Singh Negi versus Punjab National Bank and others, reported in 2009 to SCC 570. The Honorable Supreme Court has held us under page 8 to 8. Click marking it. For further, comma, perusal of Rule 66 of the Assam Police Manual, Chapter 3. No, don't say the Assam Police Manual, Part 3. Clearly indicates that the major penalties includes dismissal from service, comma, removal from service, comma, compulsory retirement, comma, reduction to a lower service, comma, greater pay or to a lower time scale, comma, recovery from pay of the whole or part of any pecuniary loss caused by the negligence. No, don't select that. Yes, cancel that. Rule 66 of the Assam Police Manual, Part 3, reads as under. Type out this. This is in page 434. B to B. A perusal of the minor penalties that can be imposed upon any delinquent does not indicate discharge from service. Stop. In the absence of any penalties with regard to discharge of service, comma, this court is of the considered opinion no, don't say like that. Discharge from service is not a prescribed penalty under the Assam Police Manual. And accordingly, this court finds force in the argument of the learned counsel for the petitioner that the Assam Police Manual does not prescribe a penalty of discharge, and therefore the same cannot be imposed upon the petition. Stop. But in view of the above, comma, this petition is allowed, and accordingly, the impugned order dated
The 13-2, my lord.
13/2/2017, issued by the disciplinary authority, discharging the service of the petitioner, discharging the petitioner from service with immediate effect, IA 13/2/2017, as well as the order of the appellate authority dated 23/9/2022 are set aside in cost. Stop. Sapara. The inquiry report dated 9/1/2017 is also set aside in cost. Stop. But however, considering the seriousness of the case involved, comma, the respondents are permitted to proceed afresh, are permitted to proceed against the petitioner afresh if so advised. Stop. The petition is directed to be reinstated into service. However, comma, as the petitioner was under suspension when he was discharged from service, he shall continue to be under suspension. Stop. The petitioner shall, however, be paid the subsistence allowance. Stop. With the officer. Which petition is accordingly disposed.
A time frame maybe, but
Oh, okay, also, if so advised, in the event, comma, if the respondents proceeds with a fresh disciplinary proceeding against the petitioner, the same shall be concluded within a period of 6 months, 6 months from the date of issuance of fresh show cause. It is also made clear that the petitioner shall cooperate
Yes.
with the at the time of disciplinary proceeding initiated against.
much appreciated.
Obliged.
You give him this one. Really required.
May it be the last. This is otherwise a matter of termination from service. Your lordship would like to take it up for disposal, then I can start with this matter. Otherwise, pleadings were completed.
Who is on the other side?
Other side will be for the government, fishery department.
Here, your lordship, otherwise, the fishery department has filed the affidavit.
Deputy Commissioner.
Deputy Commissioner has yet to file affidavit. Because here, the petitioner, he was otherwise working in the fishery department and he was dismissed from service from fishery department. But the circle officer somehow appointed the petitioner and gave him additional responsibilities. And this additional deputy commissioner and circle officer has to now file an affidavit on what authority now they have actually appointed the petitioner.
You are appearing for?
I'm appearing, that's the, I'm actually right now in a very dichotomous situation because I'm representing the government. I'm appearing as a government counsel. But the
Who appears for the fishery department?
fishery department otherwise presently MD Bora is the standing counsel. And but this was prior to her appointment. That's why the government, state government council is handling this particular matter, whole pending matter basically. But now what I've seen here, your lordship, that additional deputy commissioner and circle officer has to justify on what basis they appointed the petitioner, even though he was working as a.
So you want to file an affidavit?
Yes, your lordship.
He has already filed. I think he is appearing for respondent number 4. That is the research officer, fishery department.
Fishery department.
Now, what has happened herein is, though my substantive appointment is in the fishery department, but under the NRC, National Register of Certificates issue, I was engaged as booth level officer by the Election Commission, and there is an order to that effect in the file itself. So based on that, I was placed on deputation for the NRC related works. Whereas there was no communication or coordination between the NRC authorities and the fishery department, and therefore the fishery department initiated the process of so causing me, and finally it culminated into a dismissal on the ground of unauthorized absence. Now there are letters from the director of fishery himself, who is a superior authority, saying that I have a letter from the NRC officials, that is the deputy commissioner, that he is working there. His services are utilized there. So please release his salary, because I had already filed the case for release of salary. Salary was not released. In the meantime, I stood dismissed by the research officer based on a one-day inquiry, stating that I was unauthorizedly absent. Now, what my learned friend is saying, that they have to explain, the deputy commissioner has to explain why or under what authority he was made a BLO officer, indicates the fact that there is a misunderstanding, miscommunication between the authorities, for which the incumbent has to suffer and is to face a penalty of termination. So this is pretty clear now. The fact remains that I was appointed as a BLO. Your higher authority says that pay his salary because the officers have, the NRC level has said his services have been utilized, but he proceeds, the research officer proceeds on his own and terminates me. So the fact otherwise is this. Now I stand with an order of termination now. In the meantime, I have also retired because my superannuation age is over. So this is the position, and I have nothing now, no pension, nothing. And I'm suffering from 2022 onwards.
Problem, your lordship, because
so I think his stand that they'll have to
Your stand
explain.
has to be very clear. Whether you are appealing for fishery or the deputy.
that is where your lordship, because
So,
right now,
if you can't appear for the if you can't appear for the fishery department,
that's what, your lordship, that is the difficulty.
so there has to be 2 government councils now here on the other side.
then there you can appear for the deputy commissioner.
I will appear, madam. I will tell the affidavit.
Okay, heard Mr. A. Sharma, learned counsel for the petition. Mr. R. Dar, learned the additional senior government. Appealing for the respondents.
I think 5 and 6 will be then
5 and 6.
deputy commissioner, additional deputy commissioner.
Place for how much time you require?
Yes, you know.
My lord, 3 weeks, madam.
Place for 3 weeks time.
But I am under termination from
Election time, my lord. So this is very much busy. my
Very
lord.
shallow.
After April 25th.
List up to 3 weeks.
Lordship, kindly fix a date otherwise.
Give a date after 2 weeks.
After 7 May, any date, Lordship. 7th, after 7th of May.
Different timing.
9th,
Yes, Lordship.
9th May.
Obliged, Lordship. Election.
18.
May it please your lordship.
You ready, Sharma?
Yes, sir.
Terminated from my service, your lordship. I'm challenging the order
Your Lordship may kindly peruse the inquiry report.
This is the case of termination.
Yes, Your Lordship. I was dismissed from service, Your Lordship. The inquiry report is at page 98.
Earlier, you were given a show cause.
Yes, Your Lordship.
Where's the show cause?
The so cause notice is here, page article 53, 53, Your Lordship.
What does it say?
May I read, Your Lordship? The article of charge is at page 54, Your Lordship. May I read, Your Lordship? Page 54. Sri Kondapur Kumar Kolita, Senior Manager while functioning as branch head, Bolton Bazar, from 8/10/2012 to 6/11/2013, that is for a period of 13 months, Your Lordship, has allegedly committed several acts of omission and commission, details of which are mentioned in the statement of allegations for which Sri Kondapur Kumar Kolita is charged under. Sri Kondapur Kumar Kolita has failed to take all possible steps to ensure and protect the interests of the bank and discharge his duties with utmost devotion and diligence, which is violation of Regulation 3(1) of the UCO Bank Officers Employees Conduct Regulation 1976. Sri Kondapur Kumar Kolita has acted in a manner unbecoming of a bank officer who is violative of Regulation 3(1) of the Officers Employees Conduct Regulation 1976. Sri Kondapur Kumar Kolita, while performing his official duties or in exercise of powers conferred on him, had acted otherwise than in his best judgment, which is violative of Regulation 3(3) of the UCO Bank Office Employers Conduct Regulation 1976. And Sri Kondapur Kumar Kolita has failed to take all possible steps to ensure the integrity and devotion of all to duty all persons for the time being under his control and authority, which is violative of Regulation 3(4) of the UCO Bank Employees Conduct Regulation 1976. So these are the allegations against me, Your Lordship.
Where's this regulation of 1976?
I have not annexed it, Your Lordship. It's with me. Regulations. That is the regulation. No problem.
After 5 minutes.
Yes, sir. Regulation from social mechanism. May I read, Your Lordship? Every officer employee shall at all times take all possible steps to ensure and protect the interests of the bank and discharge his duty with utmost integrity, honesty, devotion, and diligence, and do nothing which is unbecoming of a bank officer. Then, to Your Lordship, each officer employee shall maintain good conduct and discipline and show courtesy and attention to all persons in all transactions and negotiations. 3. No officer employee shall, in the performance of his official duties or in the exercise of powers conferred on him, act otherwise therein his best judgment, except when he is acting under the direction of the official superior. And every officer employee shall take all possible steps to ensure the integrity and devotion to duty of all persons for the time being under his control. Now, I was the bank manager, Your Lordship, at that time, the senior manager of the branch. The allegation is that various loans were given without taking everything, Your Lordship. So this is the main allegations. Various loans were given. Subsequently, those loan accounts became non-performing assets, Your Lordship. And bank lost huge amount of money. That was the allegation against me. And they have, after conducting an inquiry, they have dismissed me from service, Your Lordship. Now, Your Lordship, may kindly for a moment peruse the inquiry report, which is at page 66. From the second paragraph onwards, may I read, Your Lordship? I held the inquiry in the matter of said charges at the venue of AGM chambers.
Page 66.
Page 60, sorry, page 98.
Page 98.
98, Your Lordship.
It's an inquiry report.
It's the inquiry report, Your Lordship. I'm straight away coming to the inquiry report, Your Lordship.
You replied to the show cause?
Yes, I have replied to the show cause, Your Lordship. I had denied all the allegations that were laid against me. But first, I would like Your Lordship to kindly peruse the inquiry report for a moment, Your Lordship. Page 98, Your Lordship. Third paragraph, may I read, Your Lordship? In the course of inquiry proceedings, the presenting officer submitted 155 sets of documents, all of which, being relevant to the allegation in the subject charge sheeted, were accepted by the EO as management exhibits. A copy of each of these sets of MEs were given to the CEO for information. The PO produced one management witness named Mr. Topon Chakraborty, manager of Circle Officer Guwahati UCO Bank, and presented the management case through examination of the MW as also by submission on the basis of MEs. Now, one person, Your Lordship, one person has exhibited all the documents, which is not how it should have been done, Your Lordship. That was erroneous thing because only a single person, he cannot exhibit all the documents because he is not the maker of the documents, Your Lordship. He cannot exhibit all the documents. The inquiry itself per se is wrong, Your Lordship, erroneous, because this is the only person, and the inquiry officer has categorically stated that it is one Mr. Topon Chakraborty, the manager of Circle Office Guwahati, who has exhibited 150 documents. Lordship, in this regard, I would like.
It depends on the documents, isn't it?
Yes, yes, definitely. The documents, all the documents were different documents of different bank loans, Your Lordship. Only one person. He was not the person who has given the loans. He was not the person who had taken the, who had gone through all the technicalities of the loan. There were various persons involved. He was not the single person who has done it. They should have examined many other witnesses, but only one witness were examined, Your Lordship. May kindly see the statement of the presenting officer at page 66, Your Lordship.
Page
66. Allegation number 1, Your Lordship. BMB Enterprise Proprietor Hafiz Ahmed, account number so and so, documents submitted in support of allegation number 1, material exhibit 1 to material to 113. As per allegation 111, the processing of the borrowal account was not done as per loan policy document. In this regard, I would like to state that had Your Lordship got it, and the account Messrs. BMB Enterprise was sanctioned under UCO transfer scheme code C101A by the CEO on 29/2013 for rupees 23 lakhs. As per the bank guidelines, the UCO trader loan at that point time should have been sanctioned as per the bank circular by exhibit so and so to so and so, but following irregularities were observed. The UCO trader loan is to be sanctioned for trading purpose only, but as per the trade license issued by Guwahati Municipal Corporation to BMB Enterprise, Professor Hafiz Ahmed, the business is related to manufacture of cloth and vaccine bags. Further, as per IT return of Hafiz Ahmed so and so, while material exhibit number so and so to so and so, page number 5, material exhibit 19, page number 5, it is clearly mentioned as gross receipt from manufacturer of cloth and reskin bags and its materials. Thus, the very purpose for which the loan was sanctioned deviates from the bank's guidelines. As per material exhibit 11, page number 4, for limit above rupees 20 lakhs, but below rupees 50 lakhs, latest audited financial statements has to be obtained. But as per material exhibit 1, 7, 8, and 9, the financial statements submitted are not audited, hence the guidelines were not followed. Your Lordship, from this one example, Your Lordship may find that there are so many persons who ought to have been examined, Your Lordship, at least to prove the case against me under preponderance of probabilities, Your Lordship. Not beyond reasonable doubt, definitely. But at least for the preponderance of probability, Your Lordship, other witnesses ought to have been examined. The documents that they were relying on in the inquiry report. What they had done is that they have examined only one witness, and they have, and that thereafter they have proved that I was guilty, Your Lordship. Only one witness and 150 documents, Your Lordship. The inquiry officers at page 98, Your Lordship, had very categorically clearly stated, Your Lordship, that there were 198 documents. Oh, sorry, 155 sets of documents. So this is my first contention, Your Lordship. In this regard, Your Lordship, I would like to rely on a judgment of the Honorable Supreme Court. 2003, 8 SCC 745.
2000.
3, volume 8 SCC 745, para 16. Let's see. এখন দিল্লি photo. 745. এখন দিল্লি photo. আছে নাকি?
You flag it, no, you flag it, otherwise it's difficult to go.
Yes, yes,
through.
yes. I will flag it. What's it? This one, I said. Photo flag to video.
You flag it and flag it properly, we'll take up some other day.
Okay.
It will be proper.
May I pray for a short video?
Yes, yeah, I'm giving you, after Bihu.
After,
After Bihu, because from 4th to 10th is now a motion week.
in the same way. My only
18 or election is also there.
my only respectful submission, Your Lordship, is the person he's suffering from kidney problem.
Yeah,
Your Lordship.
that
That is the only problem, Your Lordship.
I'll give you immediately on the opening day.
Yes, Your Lordship. Good to this. Almost, no?
But they would have done a council.
My good.
Also heard M. Sharma, the standing council,
For responding. Thank you.
responded back. This Dr. We'll have it on 22nd.
Yes, yes. Deep.
That is a Monday.
Tuesday it will be better. 23rd it will be better. The hearing day will be better. Please tell me. 23rd April.
You have got the reports?
Yes, sir.
You have the reports?
Yes, yes. I have bring all the.
Deeply obliged.
Eleven is. Then I have readiness to be spoken to. Not today, it's tomorrow. Tomorrow.
Deeply.
Please stop in 2 weeks.
14.
May I please, Lordship? Lordship, page number 34 of my writ petition, Lordship, Annexure 1,
Page,
34, Lordship.
yes,
This was the advertisement issued by the Director of Women and Child Development, Lordship. We are concerned with page number 36, Lordship. District Child Protection Officer. Then next one, page number 37, Protection Officer, Institutional Care.
1 minute, one. District Child Protection Officer.
Yes, Lordship.
Then
Then
Protection Care Institution.
Protection Officer, Institutional Care. And next one is page number 38, Lordship, Protection Officer, Non-Institutional Care. Let's now, Lordship, if you Lordship come back to page number 36, the eligibility criteria was defined at column number 5. According to this, the eligibility criteria for District Child Protection Officer is postgraduate degree in social work and so Lordship, and at least 3 years experience of working with the government, non-government organization, Lordship. Next, Lordship, Protection Officer, Institutional Care, that is postgraduate degree as well as graduate in social work and so Lordship, with experience of 2 years, Lordship.
Where's that with experience?
It is or
graduate in social work, around 5 line below, Lordship.
Yes.
Similarly, Lordship, protection officer, institutional care also, Lordship, page number 38, postgraduate as well as graduate and 2 years experience, Lordship. From this itself, it is evident that DC post of district style protection officer is superior to protection officer institutional care and protection officer non-institutional care, Lordship.
Officer,
District child protection officer is superior to the protection officer institutional care and protection officer non-institutional care, Lordship. Lordship, along I have on the other day, Lordship, I have submitted the implementation guideline of Mission Bachilla, Lordship. It is there in the record, Lordship.
implementation guidelines.
Yes, Lordship. It was circulated by the letter dated 5th July 2022.
Yes.
If your Lordship come to page number 56, Lordship.
Of this
Of
compilation.
this, yes, Lordship.
Yes.
Page number 56, this is District NSF 2, Lordship. Roles and responsibility of the duty holders of DCPU, District Child Protection Unit, Lordship. This is Protection Officer Institutional Care, Lordship. This first line itself, it starts with under the supervision of DCPU, Lordship. So, Protection Officer Institutional Care is below the post of DCPU, Lordship. Similarly, 2, Lordship, at page number 57, Protection Officer Non-Institutional Care, Lordship, under the supervision of DCPU, Lordship. Lordship, thereafter at page number 60, Lordship.
Yes.
B, Lordship, selection process of staff under the District Child Protection Unit, DCPU, Lordship. Lordship, this is point number 1, Lordship. A selection committee constituted by the state principal secretary headed by district magistrate shall head the selection committee for selection and appointment of staff of DCPU. The district selection committee may include district level officer, for example, district program officer, district social welfare officer, chairperson, member of CWCU, member of JJB. Next point is, Lordship, once the district child protection officer DCPO is appointed either by deputation or contract, she shall also be a part of the selection committee. That means, Lordship, DCPO is a member of the selection committee to select candidate for the post of protection officer institutional care and protection officer non-institutional care, Lordship. So he is definitely superior, Lordship. Next, Lordship, at the same time, Lordship, we may go to the point number 2 and 3 also, Lordship. State government, district administration may preferably appoint regular staff at supervisory position like DCPU. And third one is all the manpower to be engaged under Mission Bachilla will be on the basis of prescribed qualification and experiences, Lordship. Lordship, as per this mandate, Lordship, if your Lordship now come to the affidavit in reply, Annexure 1, page number 151, Lordship.
Affidavit in reply.
Reply, Lordship.
151,
Lordship.
Yes.
As per this mandate of the Mission Bachilla, Lordship, they have constituted a committee for selection of the staff of DCPO, Lordship. In suppression of all previous notification orders on the subject and in pursuance of the Mission Bachilla implementation guidelines issued on 5/7/2022, and in order to select contractual staff in various positions of district child protection units and government-run child care institutions under Mission Bachilla, a district level selection committee is hereby constituted, consisting of the following members. These are the members: Deputy Commissioner is the chairman, chairperson, and Superintendent of Police, District Social Welfare Officer, Member Secretary, District Child Protection Officer, DCPO is the member of the selection committee, Lordship. finance and so, Lordship. Now the functions are described below, Lordship. The functions of the committee will be as follows: to conduct and oversee the process of selection of candidates for various positions in district child protection unit, government-run child care institution other than DCPO, Lordship. Other than DCPO, including holding of written examination, Fivavasi and computer proficiency test, Lordship. This is not for the DCPO, Lordship, but below the post of DCPO, Lordship. Next point is the committee shall lay down DCPO is District Child Protection Officer, Lordship. The committee shall lay down the process of selection to prepare the select list of candidates for appointment to different categories of positions, then DCPO, not for DCPO, Lordship, then DCPO, as per eligibility criteria laid down in the Mission Bachelor guideline. The committee shall follow the rules and regulation guidelines laid down by the state government with regard to minimum and maximum age limit. The committee shall be responsible for setting question papers, their secrecy, evaluation of answer scripts, and compilation of results. After the conduct of process, the deputy commissioner shall keep all relevant records in safe custody. To complete the selection process within the stipulated time frame as laid down in the terms of reference for selection, it shall be within the rights of the committee to modify in part or in full any list if find necessary to do so for reason to be recorded in writing. The number of selected and recommended candidates shall not exceed the number of vacancies advertised. The select list of recommended candidates shall be sent in a seal cover immediately after the process is over to the member secretary, State Child Protection Society, Assam, for further necessary action. This is the committee constituted. Function are also written down, Lordship, and this committee is supposed to select the member other than DCPO, Lordship. DCPO is a member of this committee also, Lordship. But what they have done, Lordship, if your Lordship come to the affidavit in opposition filed by respondent number 3, Lordship. From my affidavit in reply, Lordship, that letter was to constitute the district level selection committee was on 13th October 2022, Lordship. Now in at page number 99 of the affidavit in opposition, Lordship, this letter Annexure B, Lordship, page number 98, Lordship, page number 98, Lordship, Annexure A. This letter is dated 24th of August 2023. That means after issuance of the district level selection committee, formation of the district level selection committee on 13 October 2022, Lordship. This letter was written by Member Secretary, State Child Protection Society, Assam, to the Director, Women and Child Development, Assam, Ujan Bazar. With reference to the subject cited above, I would like to inform you that various positions of construction staff under Mission Bachelor are lying vacant at state and district level. The vacancy status is enclosed herewith as Annexure A, along with details of the post as Annexure B. In this regard, you are requested to kindly conduct the recruitment process to fill up the vacant position. After the recruitment process, you are requested to submit the final list of selected candidates to the undersigned. After formation of the district level selection committee, Lordship, they have again, Member Secretary requested that the Director of Women and Child Development to initiate the recruitment process, Lordship. And what the Director of Women and Child Development did at Annexure B, Lordship, page number 99, he himself has constituted a selection committee. In the interest of public service and for smooth functioning conduct of examination on various positions under Mission Bachelor, in pursuance of letter received from the member secretary SCPS Assam, file number so and so, dated so and so, the selection committee is constituted with the following members. Director, additional secretary, additional director. None of the member is there from the district level, Lordship, or from the state levels, Lordship. So against the mandate of the mission Batchello, and after formation of the district level selection committee by the principal secretary, Lordship, the member secretary is state child protection society, Lordship. He has requested that the director of women and child development to conduct a recruitment process, and after that the director of social welfare, the director of women and child development constitute a committee to conduct the examination, Lordship.
My friend will continue on this. I'm indicating, kindly give me for me to answer. But whatever submission he is making, he should relate to the pleadings of the case. These are not pleaded at all. Whatever is being pleaded in the petition and whatever submission is made in the before your lordship today, well, there is no connection with that.
It is their Lordship.
Let him refer to the pleading.
Yes,
Let him refer
Lordship.
to the petition.
Yes, Lordship.
Because now what he has been indicating is absolutely a different thing.
They have committed illegality, Lordship.
No.
That is evident from
I'll submit.
Lordship,
Let him,
Lordship,
from the pleading, let him show.
yes, Lordship. Lordship, this advertisement is issued, and after that, Lordship, if your Lordship again come to my writ petition, Lordship, at base, I have taken a definite stand, Lordship, regarding constitution of the committee. Though I could not elaborately take the stance, Lordship, but
Where?
Lordship, I have taken. At page number 23, Lordship, of my writ petition, paragraph number 18, Lordship. The relevant portion is page number 23, last portion, Lordship. Last portion of paragraph number 18, Lordship. The petitioner further doubt whether the selection committee has been duly constituted as per the norms as laid out in the guidelines, Lordship. It was not elaborate because, Lordship, why I could not elaborately take the stand, Lordship, that also I can convince your Lordship, Lordship.
See, Chaudhary,
Yes, Lordship.
here this statement is that you're having a doubt.
Yes, Lordship.
But then in the affidavit, they've come up with the selection committee.
Yes.
Yes, Lordship.
In your reply, you've come with a different selection committee. Correct?
Yes, Lordship.
So once the affidavit is filed,
Yes, Lordship.
and you find that there's something wrong with that selection committee,
Yes, Lordship.
you could have amended this writ petition.
Because I have taken that stand, Lordship. There are some other grounds also, Lordship. What if your Lordship come to advertisement after that, Lordship, if your Lordship come to page number 66, Lordship, of my writ petition, Lordship. On 16 February 2024, they have informed the candidates. This is for information of all concerned that OMR-based MCQ examination for the following post under Mission Bachelor published by advertisement so and so will be held on 25th February 2024. And accordingly, Lordship, on 25th, the examination was held, and page number 67, Lordship, on 27th, they have published the result. There was an addendum also at page number 69, Lordship, on 28th. Lordship, what happened? Neither in the advertisement nor in this notification that is 16 February 2024, they have not declared that they are going to hold only one examination for all district child protection officer, probation officer, and protection officer, institutional care, protection officer, non-institutional care. The petitioner was under the impression that two different examination will be held for this three post, Lordship, but they have conducted only one post, Lordship. And particularly, Lordship, neither in the advertisement nor in this notification, they have mentioned regarding cut-off mark, Lordship. Nowhere it is declared in the notification or advertisement, what will be the cut-off mark, Lordship. There is no standard anywhere regarding cut-off mark, Lordship. They have never published anything in that regard, Lordship. Now, Lordship, if your Lordship come to their affidavit in opposition, Lordship, they have hold around 2-3 meetings, Lordship. They have decided regarding cut-off mark, Lordship, but not published anything. This was at page number 99, Lordship. This was the selection committee constituted, and thereafter, Lordship, at page number 101, they have taken certain decision. And now, Lordship, if your Lordship come to page number 101, Lordship, if your Lordship see the date of the meeting, Lordship, this
See,
is
Chowdhury, are you assailing this selection committee? Because you're saying that this is not done in terms of the guidelines of that particular scheme.
yes, Lordship. I have not assailed the selection committee, Lordship, but there consequently action of conducting the examination and publication of select list.
So you're okay with the selection committee?
I am not okay, Lordship, because it was not known to be earlier, Lordship.
This is what I'm trying to tell you.
Yes, Lordship.
See, first ground is that what you have said is you've taken me to the guidelines
Yes, Lordship.
of that, what you call that, Vatsalya something.
Yes, Lordship.
All right. Which provides that this should be the selection committee.
Yes, Lordship.
In your affidavit in reply, you have annexed a committee which was issued by the principal secretary.
Yes, Lordship.
You're happy with that selection?
Yes,
committee?
Lordship.
But when they filed the affidavit in opposition,
Yes, Lordship.
they've enclosed this committee which is constituted by the director,
Yes, Lordship.
where many officers are missing.
Yes, Lordship.
Correct?
Yes, Lordship.
So you could have amended the writ petition challenging this.
But even if I do not challenge that, Lordship, this is prima facie and expressly clear that a wrong committee has conducted the selection recruitment process, Lordship. Has, Lordship, it will be from the point of law, it will be justified that committee, the consequential effect, that is conducting the recruitment process and publication to select list by a wrong committee, will be justified, Lordship. Lordship, why I am telling, while filing the writ petition, I had to file this writ petition in a very hurried way, Lordship.
That's fine. That's fine. We understand that. You had to file in a hurried way. You're not aware what was who was the
Yes,
selection committee. But after they filed the affidavit in opposition, you could have prayed for amendment of the writ petition or filing an additional affidavit.
In that case, Lordship, I have to file. Lordship, I was not aware about this after the filing of this.
That's what.
Then kindly allow me to amend, Lordship. Otherwise, it will be highly unjustified, Lordship, if this selection process is.
After all, the pleadings are complete.
Lordship, they are just trying to developing their changing their things from this to that. Page 41 is the advertisement issued by the director, WCD Assam. They have responded to that. And if they are insisting on the guidelines which they have referred today, then in that case, if they are insisting that that should be the selection process, why they have responded to this advertisement? Look, what they have done, they have taken part in the selection process. They have taken the chance when they found that they were not selected. They are working. They are working temporarily in the last previous tenure. They were appointed. They got selection. This time also they took part. I'll show in the writ petition they have annexed. The advertisement was issued by the Director, Women and Child Development, and they responded to that advertisement. Now they said that this particular director has no authority. That is what they want to submit. if they are at all aggrieved by the advertisement, they could have very well challenged the advertisement at that stage. But they have not. They have taken all the opportunities. And but we have in our affidavit stated in detail that the qualification for this post are same. But the APSC is holding a common exam for the post of ACS, APS, for the cooperative officers. The common exam has been held by the APSC, and they are the candidates. They used to give preference. Whatever same thing has happened here. But they have given their preference to this post, first preference to this post, second preference to that post, like that. They have chosen while filling up the application form. They have taken all the opportunity to contest, to participate in this particular selection process. Only after failure, now they are trying day by day, they are trying to find fault. And this particular guideline, 22 guidelines, it was very well. They have, it's even not a part of the record, but they have given it to me, they have given it to the lordship. It's okay. But this is of 22. Whether this guideline is not so sacrosanct that this is binding, this is the guideline only, my lord. Lordship knows the law relating to the guidelines, my lord.
According to the guideline, Lordship, the district level selection committee was
Then
formed.
why they have responded to this district, the advertisement issued by the director?
No, what they're trying to say is they've responded to the advertisement,
Lord,
but they are not aware of the selection committee, constitution of the selection.
no, those things are, decisions have been taken by the authority and not only in respect of these petitioners, my lord. Throughout the entire state, my lord, the candidates they have participated in the process, my lord. Ultimately, what now they have, my lord, they are trying to say that cutoff mark. We have not, so my lord, ultimately a decision has been taken that out of the candidates, how many persons will be called for the interview? 3:1, 1:3, for 1 post 3. Otherwise, everybody cannot be called.
Lordship,
That,
Lordship,
is it so unfair? Well, had the petitioner been selected, these things would not have come. So lordship, the conduct of the petitioner is very important. Kindly, that aspect cannot be ignored.
Lordship, that 1:3% is also not followed by.
Out of 1:3, if had they been inside, then everything is fine. Everything is okay. Since now they are not within that, everything is bad.
Lordship,
And that too after filing of this writ petition, after filing of the affidavit in opposition.
Lordship,
And the OMR based selection process, it is not so that it's not in the domain of anything. The OMR is not a recognized thing.
Lordship, if your Lordship come to page number 135, Lordship, I have not specifically assailed that selection committee, but I have stated something, Lordship. 135 of my reply, Lordship. But I have above I have described about the Constitutional Committee, Lordship. If your Lordship at page number 135, Lordship, down last paragraph, Lordship. In pursuant to the said notification dated so and so, letter dated so and so, the member secretary, State Child Protection Society, Assam, while informing the deputy commissioner cum chairperson of District Child Protection Committee, all the district regarding formation of DLSC for recruitment process of contractual staff of DCPU and government run CCIs under Mission Bachela, it was further informed that the advertisement of filling up various positions will be issued centrally by State Child Protection Society, Assam, and only after issuance of the advertisement by SCPS, the process of recruitment may be initiated. So after telling such, Lordship, last 4 or 5 line above, Lordship, said letter dated 24/8/2023, the Director of Women and Child Development, Assam, cannot constitute the selection committee as constituted by order number so and so, dated 19/9/2023, as such the selection process conducted by the selection committee as formed by the Director of Women and Child Development, Assam, by the said order dated 19/9/2023 is bad in law, and as such same is liable to be set aside and quashed, Lordship. I have taken in my reply, Lordship.
In the additional affidavit, they cannot pray. In the additional affidavit, they cannot pray Prayer is in the writ petition, Lordship, within the four corners of the writ petition it has to be decided. At least see the grounds, Lordship may not allow these things to be.
Considering the
just,
circumstance, Lordship, I had no other option,
Then,
Lordship.
then Lordship
Because
has
I was
indicated
not
he has to
known
amend.
that about the selection committee, I had no knowledge, Lordship. I thought that properly constituted selection committee had conducted the test, Lordship. But afterwards only, I had come to know they have conducted the through a wrong selection committee, Lordship. That selection committee has no authority, Lordship. Lordship, again, Lordship, if you're after formation of selection committee, Lordship, page number, Lordship, if you my reply, Lordship, 153, Lordship, page number, annexure 2, 153, Lordship. After formation of the district level selection committee by the principal secretary of the government of Assam, the mission director, State Child Protection Society, has informed all the deputy commissioner and chairperson, Lordship. I would like to inform you that in order to take forward the matter related to recruitment process of contractual staff of DCPU and government-run CCAs under Mission Bachilla, the government has constituted the district level selection committee. In this regard, it is informed that the advertisement for filling up the various positions will be issued centrally by the SCPS Assam. The process of recruitment may be initiated after issue of the advertisement by the SCPS Assam. So that district level selection committee constituted by the principal secretary was empowered to conduct the recruitment process, Lordship. But instead of that, Lordship, the committee constituted by the director of Women and Child Welfare has conducted the recruitment process.
This you have not pleaded in your writ petition, isn't it?
I have.
Kindly see 153.
Lordship, kindly allow me to submit, Lordship.
Kindly allow me for
No, Lordship, this way it will not impossible, Lordship.
No, I just indicate.
He will get chance, Lordship.
No,
At
I'll just indicate one thing, because he
is a
Page
senior
one-
government
page-
advocate,
page
Lordship. He can
153.
continue after me.
Not what do you want to try to impress?
page 153 he has referred. But he is insisting that member secretary has directed all the deputy commissioners that committee has been constituted, they will conduct it in the centrally. The same member secretary has now page 98 in the affidavit, we have said that now they have said that the director, women and child will conduct the selection. He said that the letter of December 22 regarding earlier process, that will prevail, not the subsequent letter at page 98. The same member secretary has now said that the director will conduct the selection. What reason, Bala? Page 98, page 98. He is harping on this 153.
Without withdrawing that committee, Lordship, he cannot now direct the decision.
Some person has said.
Lordship, again, Lordship, one point I want to show you, Lordship, at page number 101 of their affidavit on opposition, Lordship. Illegality is prominent in this letter, Lordship. Their affidavit in opposition, Lordship, page number 101. See the date of this letter, Lordship, 22nd of September 2023, Lordship. Heading is minutes of the meeting of the selection committee for recruitment of various categories of posts under Mission Bachilla held on 20th September. Meeting was held on 20th September. The date of the meeting is 22nd of September. Now same letter, Lordship, page number 102, Lordship. Next page, Lordship. See the date below the signature of the Women and Child Development Assam, Lordship. This is dated Guwahati, that 10 September 2024, Lordship. The meeting is dated 22nd September 2023. Meeting was held on 20th September 2023, and that in the second page is 2024, Lordship. This simply shows that they have done something illegality in the year 2024, Lordship. And to make that legal only, they have these meetings are formed, Lordship, and they have some compilation of minutes of the Lordship. Because 2024, if a person in the year 2024, Lordship, then only he can write 2024. Not a person who is in the year 2023, he will write 2024, Lordship. So from this, it is, if it, Lordship, again, Lordship, they have in the minutes of the meeting, they have shown that candidates at the rate of 1:3 will be called for Fivavosi. Lordship, if your Lordship come to that point at 1:3 will be called for interview, Lordship. But however, Lordship, they have not called candidates at that rate, Lordship. Because if your Lordship come to my writ petition, the result sheet, Lordship. Result sheet at page number 67 of my writ petition, Lordship. This is the result of DCPO, POIC, and PONIC, Lordship. Total post, as per the advertisement, I can show, Lordship, the total post is 51, Lordship. They have called through this 153 candidates, and one addendum is there, Lordship. There were few persons, and we add that one 171, Lordship. So 51 out of 51 posts, they have called 171 posts, Lordship. That should be 153 candidates should have been called, but instead of that, they have called 171 candidate, Lordship. Second one, Lordship, page number 68, Lordship. Page number 68, total post is 28. They have post is 15. They have called candidate of 28 number, Lordship. Should have been called 45 candidates, Lordship. And third one is, Lordship, the post is 50 and they have called candidate only 62. They should have called 150 candidates, Lordship. Illegality is everywhere, Lordship. Lordship, if your Lordship come to the minutes, nowhere it is stated that they have decided on qualifying marks of the written examination, Lordship. Minutes, I can go, if your Lordship go to the minutes, Lordship. First minutes, it will get 101 of their affidavit in opposition, Lordship. Page number 101, Annexure C, Lordship. These were the decisions taken to prepare advertisement in consultation with member secretary SCPS. Online application will be invited, so and so, Lordship, to publish advertisement in newspaper. The candidates will be eligible to apply in the post as per zone clubbing of districts, which will be made in the online portal. This approach is made considering the nature of job of post under Mission Bachillo, favoring candidates from same or neighboring districts for enhanced performance, adopting an online application system restricting candidates to specific zones through the clubbing of district. Examination will be held, total 100 marks. 70 marks will be for written test. The qualified candidates will have to appear for Vivavosi skill test wherever required for remaining 30 marks. Additional marks may be awarded during Vivavosi skill test for candidates with relevant work experience under Mission Bachelor, which will be determined later on. The merit list select.
Yeah, you're jumping from here to there.
No, no.
Why don't you make your submission systematic?
Yes, Lordship.
See, issue is this: an advertisement was made.
Yes, Lordship.
You submitted your application.
Yes, Lordship.
You participated in the selection
Lordship.
process, correct?
Yes, Lordship.
Then results were published.
Yes, Lordship.
Till then, there was no any objection from your side.
Because, Lordship, when we went for the examination, Lordship, at that time we thought there will be two separate examination, Lordship. But on 25th, when we went for examination, then we came to know that there was only one examination.
But then you did not complain, isn't that? You said for the examination.
No, we did not make any complaint to the authorities, Lordship. But I have made a specific stand in this regard, Lordship, in my affidavit in reply. Lordship, we have not made any complaint.
So you were under the impression that two examinations would
Yes,
be held.
Lordship.
But then they conducted only one examination.
Yes, Lordship.
But then you participated in the examination.
Yes, Lordship.
Then you kept quiet
Lordship.
till the results were published.
Yes,
isn't
Lordship.
it?
Yes, Lordship.
After the results were published, only you came to court.
Yes, Lordship.
So, see, when you were under the impression that two examinations were going to be held,
Lordship,
and they held only one examination, immediately after that, you could have come to court.
that impression is visible from that aspect, Lordship. That impression is visible, but we are not sitting. We have made specific stand, Lordship. We are about to approach this honorable court. But on 25th, the written examination was conducted, we participated, and on 27th, they have published the result. We got no time to approach a lawyer and to approach the honorable court, Lordship. And after that result was declared, finding no other alternative, we immediately on 1st of April, we filed this writ petition in a hurried manner, Lordship. And because of that, we have lost many relevant documents also. We could not compile, could not annex with the writ petition. But after the filing of the writ petition, after this court granted a stay order in publication of the result, Lordship, we have collected so many documents, and from that, Lordship, it is prima facie and explicit here that the wrong committee conducted the institution.
So that is, see, that is the issue. First, your writ petition is confined to advertisement,
Yes, Lordship.
application filing,
Yes, Lordship.
conducting of examination,
Yes, Lordship.
participation.
Yes, Lordship.
You were not found fit. I mean,
Yes, Lordship.
you were not
Yes, yes.
found selected. So you came to court.
Yes, Lordship.
That is your writ petition.
Yes, Lordship. That much only. We, in that writ petition, though we could not annex any documents as such, but we have taken many stands, Lordship, regarding qualifying marks also, that if you have failed in any all aspects also, we have specifically taken a stand that no qualifying marks for the written examination was stated, neither in the advertisement nor in subsequent notification, Lordship. Lordship, in regards to qualifying marks, Lordship, there is no standard that if there is a written test for 100 marks, the qualifying marks obviously has to be 50, 40, 30 or anything, Lordship. Qualifying mark is to be prescribed by the recruiting authorities, Lordship. In this case, Lordship, nor in the notification, neither in the minutes of the meetings, Lordship, conducted by the selection committee, they have decided on qualifying marks, Lordship. But on that count itself, this recruitment process needs to be set aside and quashed, Lordship. Moreover, Lordship, this and that of the minutes of the meeting, Lordship, this is physically perfectly clear that they have committed some illegality, because in the year, when they were in the year 2023, they were writing the date on of the year of 2024, Lordship.
No, that is
Subsequent, Lordship, but illegality is visible, Lordship. In that case also, will Lordship allow this recruitment process to continue, Lordship? Where the recruitment process, constitution of the committee is wrong, where minutes of that of the meeting is wrong, where there is no qualifying mark prescribed, where the candidates as the reps.
You are taking several grounds.
Lordship.
Constitution of committee is wrong.
Yes, Lordship.
Minutes of the committee is wrong.
Yes, Lordship.
Have you taken this in your writ petition?
Yes, Lordship.
Where? Where is the challenge to the committee?
Committee silence I have shown, Lordship. I could not take a specific ground, but I have doubt that part I have stated in my writ petition, Lordship. This is at page number 23 regarding the committee, Lordship.
20?
Page number 23. Last part of paragraph 18, Lordship. The petitioner further doubt whether the selection committee has been duly constituted, because at that time I have no option, other option, Lordship. Regarding polling of candidates, the petitioner at page number 25, Lordship, paragraph number 21. That the petitioner begs to state that in the advertisement, it was not mentioned anything regarding how many candidates should be called for the viva voce from the qualified candidates in comparison to the vacant post. That again shows lack of transparency in the recruitment process. Then, Lordship, page number 26, Lordship, paragraph number 25. That the petitioner begs to say that selecting candidates for all the three categories of posts, that is DCPO, POIC, PONIC, through a single written examination is illegal and impermissible as per the relevant guidelines, and as such the notice published on 27/2/24 and addendum dated 28/2/2024 selecting candidates to appear in viva voce is illegal and liable to be set aside and quashed. Lordship,
what does the guideline say about the?
Lordship, DCPO post, DCPO is the member of the selection committee for the other post of the DCPU, Lordship. So they cannot conduct a single test for DCPO, POIC, PONIC, Lordship.
No, you are saying with a single written examination is illegal.
Is illegal, Lordship.
And not permissible under the guidelines.
No, sir, Lordship, because selection.
What does the guidelines say that there can be no single selection?
But Lordship, that selection in the DCPO selection committee, DCPO is the member, Lordship.
maybe this court is asking you one question.
And that, Lordship, I have annexed my, so that, in my reply affidavit, Lordship, that letter is there for other than DCPO, Lordship.
That I've seen.
Then this committee has selected all the candidates together,
After this committee was constituted,
Lordship.
then the director constituted another committee, is it?
Yes, Lordship.
So this is the issue in here.
Yes, Lordship.
So what you're trying to say is the first committee should prevail, not the second committee.
Yes,
Correct.
Lordship. First committee should prepare the selection, conduct the selection process, Lordship. Committee constituted by the principal secretary, that has to continue conduct the recruitment process, Lordship.
But that ground if not taken, this is what this court is finding it difficult.
That I have taken.
You're just making the oral submission.
No,
without
Lordship, I have at page number 20, paragraph number 23, I have taken, though not specifically, Lordship. Because
that is a very vague statement.
but considering the illegality, Lordship, regarding constitution of the committee, Lordship, at that time, I can only guess, and I had some doubt, and because of that, I have taken that stand, Lordship. But in my reply, Lordship, after coming to know about this committee formation of the committee, Lordship, I have taken specific stand, Lordship, in that regard. Because while filing the writ petition, Lordship, I have no total knowledge about the constitution of the committee. After filing the affidavit in opposition, then only I have come to know. And when I compared this selection committee with the mission guidelines, then only I came to know that the selection committee is wrongly constituted, Lordship. And after that, when I filed my reply affidavit, Lordship, then I have specifically stated that the committee formed by the Director of Women and Child Development is wrong, Lordship. And that committee cannot conduct the recruitment process, Lordship. Looking at the circumstance, how the writ petitioner has to come to the before this honorable court, this stand has to be taken in that way only, Lordship. Had the writ petitioner had enough time to plan and to compile the relevant documents, Lordship, then it could have been taken the stand in the writ petition itself. But this is a specific in some different circumstance, Lordship, and in that case, this and specifically considering the illegality, specifically specifically the constitutional committee, all these aspects, if it, Lordship, taken in entirety, Lordship, this recruitment process has to be quashed, Lordship. And I most humbly pray that if this process is allowed by this honorable court to continue, Lordship, this will be a total injustice to the petitioners, Lordship. In my submission, respectful submission, Lordship. Glenn, Lordship, I have against, yes.
Chowdhury,
Yes.
I'm finding your submissions okay, fine. But you're traveling beyond your pleadings.
I accept, I admit, Lordship, I concede that there is some.
So what do we do now? Can we permit you to submit beyond your pleadings?
But that polling of candidates from 1:3 ratio, Lordship, that was not followed. That stand I have taken, Lordship. Committee, I could not. Lordship has to give some consideration in this aspect, Lordship. Specifically on 25, the written test was conducted. 27 and 28, they have declared the result. How the petitioner would get together and how they will approach the lawyer. Lawyers also take some days, Lordship. But in this case, Lordship, immediately on the next day itself, 29 was the last date for the month of February, Lordship. 29th, the petitioner approached the lawyer, and on 1st of April, at around 10 o'clock, Lordship, they have filed the petition, and mention was made before this honorable court to list that matter on the same day.
1st of March.
1st of March, Lordship. So that was that only could be done by the petitioner at that state, Lordship. Had there been some time, if they could have get some time to file this writ petition, they could have taken all the stand together.
What happened after the affidavit was filed by the respondent?
After that reply affidavit, specific stand was taken, Lordship.
You could have amended the writ petition.
Then allow me to kindly allow
That
to.
will be, that is too late in the day.
But in that case, that committee consequential effect has to be stopped, Lordship. If I cannot, because of my pleadings that I have not challenged the committee, Lordship, in that case, that committee, if your Lordship cannot set aside, then their effect has to be cancelled, Lordship. Because that committee does not has the authority to conduct the recruitment.
That's
process.
fine, that's fine.
So I have.
Assuming this court is agreeing with you, in terms of the guidelines, the principal secretary constitutes the committee. Then after that, the director comes to the second committee. So this court can easily come to the conclusion that no, in terms of the guidelines, this committee is wrong. This committee should have been constituted of so and so, so and so, so and so persons.
Yes, Lordship.
Correct. But then that notification by which the second committee was constituted is not under challenge.
But there is some special circumstance in this writ petition is that I have taken the stand not in the proper manner, but here and there I have taken the stand, Lordship, considering the special circumstance of this filing this writ petition, and considering that I have then also taken the stand, Lordship. Your Lordship may be pleased to set aside this recruitment process, Lordship. That will be my submission, Lordship.
That is fine. That is fine. That's very easy for you to submit, but for this court to pass an order on the basis of your writ petition.
But
why don't you think it over and come back?
That Lordship, allow me to amend the writ petition, Lordship. Otherwise, I have no other option.
If you have come with that prayer immediately after they filed the affidavit, this court could have permitted it. But then you filed your reply.
Then
it is for admission hearing today.
In reply also, Lordship, I have taken that stand, Lordship.
That you have taken, there's no doubt on that.
After
But
coming to
still
know
there's no challenge to that notification.
after coming to, I have taken that committee cannot conduct that. That is bad in law. I have taken that stand, Lordship. In my reply affidavit, Lordship. So considering the entirety of the issue, Lordship. Otherwise, Lordship, if the recruitment process conducted by this illegal committee is allowed to be continued, Lordship, this will be the total injustice, Lordship.
That's fine. This court understands your anxiety.
Writ
But then
petition, Lordship, writ petition,
It's not under challenge.
writ petition is not to be followed the strict rule of civil procedure code, Lordship. This has the equity jurisdiction also, Lordship.
That
Under
equity
the
is
circumstances, Lordship.
the jurisdiction under 226 is quite wide. Hands
Yes,
are quite
Lordship.
long. But then at least you should give us some materials to show that because of this thing has happened.
The documents I have annexed, Lordship, from where it is palpably clear there is glaring illegality, Lordship. And that of the meeting, Lordship, 24, when they are sitting in the year 23, Lordship, polling of candidates, not in 1:3 ratio, Lordship. All this entirety, Lordship, equity jurisdiction, wider jurisdiction under
24 one,
Lordship,
that 24 letter,
Lordship.
where the committee set on.
Yes, Lordship. It is at 101 of their affidavit in opposition, Lordship. Page number 101. Next page 103 is the 10th September 2024. Lordship.
Not what date is this?
September 24 has not yet come. Not yet come. Well, it's a typographical error. It's a wrong. September 24. We are in April 24. September 24 has not come. It's a typographical error.
If it's 22nd September 2024,
23.
then we could have understood that it was a typographical error.
Lordship.
Here on top is 22nd September 2023.
Yes, yes.
Here is 10th September 2024.
But the first page, kindly see the contents below. the minutes of meeting of the
That we
selection
see.
committee on 20th of September meeting was held, and this is issued extracting the minutes of the meeting. This is an order on 22nd of after 20. Meeting is minute, it's a different proceeding is there. This is not the proceeding of the meeting. The minutes has been extracted, and this has been member present and said, hey, that this has been issued.
Whether this date has been corrected in the original file?
That I can produce it before your question. Otherwise, September 24 has not come. It's a type of equivalent. I have no difficulty in producing this one. September 20 meeting was on 20th of September, and it was issued on 22nd of September.
That's fine. Up to that part is fine,
Yes,
but then the
The
letter part
next week,
issue
next week.
date.
Memo number when the issue number has been given. It's a
10 September 2020.
because of copy pasting maybe.
No, copy pasting, that is a different thing.
Sure.
If it is 20 September, on top it is written 22nd September 2023.
Malad.
Here, if it is written 22nd September 2024, then this code could have easily said this is a typographical error.
True.
But then the dates also are different.
10. While copying or doing something, it may happen.
Obviously, copy paste won't be 2024, it will be 2023.
Yes, Lordship.
2024 has not come, so there will be no copy paste.
Malad, this 10th September, Malad, they may have copied from and pasted.
No, copied from where 10 September has not come.
No, 10th September 23.
Copy paste will not happen.
It was on 20th of something like that. Malad. I can very well verify. Malad. I'll whatever is the record, I'll place it before you.
You have the records.
I have no. I'll just check with them. I'll ask them. Whatever is in the file, I'll place it before you. I have no issue on that. I have no issue.
Why don't you verify and come?
I'll definitely.
By today, tomorrow?
I can very well ask them, Malad, by today. I can come before Lordship.
In the meantime, you also think about it. What should be your next step?
If your Lordship does not allow me to amend at this stage, Lordship, then I have to stand like this only, Lordship.
Malad, the
Because there is no other way.
petitioners they have submitted Malad, so many
No,
things.
the basic issue in the writ petition, greetings, is advertisement is made, petitioners applied for the post, they participated in the examination. They were under the impression that 2 exams will be held, but then you conducted only 1 exam.
Lordship,
1 minute.
Lordship,
This is
that,
what-
that I have taken note of. I'll have a reply to that.
They were under the impression 2 exams will be held, but then you held 1 exam. Anyway, they participated in it. And they were waiting for the results. Of course, result came within 2 days.
Yes, Lordship.
It's an OMR computerized.
So it's an OMR that is understood.
Yes.
So it came in 2 days.
Hmm.
You were not selected. So you approached this court. That is in short.
That is impression, Lordship.
That is in short, your writ petition.
Yes.
Then you start modifying everything in the affidavit in reply.
Affidavit in reply, they cannot. Lordship has rightly pointed out. Lord.
What you are trying to do is, you are trying to improve your case.
No, Lordship.
Through your affidavit in reply.
So, Lordship, in the writ petition, will say we have taken so many stands, Lordship. Only in reply, we have elaborately after getting their affidavit
blank
opposition,
files.
Lordship.
Those are blank files.
Not blank fires.
Those are blank
Evidence.
files without any basis.
No, Lordship. That
They
is
don't
not
have
blank
a-
fire.
They don't have any documents to
Lordship,
support that.
if your Lordship come to my writ petition from the day one, what I have been submitting, Lordship, with that itself, we can stand, Lordship.
Okay.
But as regard their apprehension, just I can from their petition only I can just point out. They're not making this is not a correct submission. Lakshmi, kindly for a moment come to page 42. These are all after. Kindly come to 42, my lord.
Yeah, that I've seen. Preference 1, 2, 3.
Preference 1, preference 2, preference 3. And kindly see page 52. This is the same, my lord, the person's name is Lipika Burman. Okay. My lord, before I take your lordship to the other page, kindly come to again 42, my lord. My lord, 42, Lipika Burman. She is from Bongaigaon. She has given preference for district preference district kindly at the below my lord, Bojali. Not the second last column, preferred district. This preferred district, Bojali. Under the heading district preference, kindly see my lord, district preference. She has preferred the district Bojali. And the personal details there lordship will find the present address is Kamrup Metro and the original address is from Bongaigaon. So she has chosen and she has taken part in respect of another district, Bojali. Then let kindly come to page 52. The apprehension, they said that separate exams will be held. On that one, I'm submitting. Page 52, this is the admit card given to her. Post preference, kindly see the first column, page 52. District Child Protection Officer, non-institutional care. One admit has been given. Exam time 11 to 12:30. This was given to her, not on 25th. Lord. She applied on 17th of October 2023. Admit was given to her much before that. Admit card was given, and there the time of examination has been mentioned. That exam for both the post exam is going to be held on 11 a.m. to 12:30 p.m. on one day. How they can before your lordship, how they can now submit that I was under an impression that separate exam will be held. So these are all afterthought, wasting the time of the honorable court.
Take that. Heard Mr. A.T. Chowdhury and the petition. Also heard Mr. Dina, then the additional senior government. And Mr. Emma, okay, also heard Mr. Emma Adigari, Leonard. CJC.
Yes, madam.
For the respond number 1 and Mr. Dina, then the additional senior government. For the respondents, 2
for
5.
For yes.
When do you want?
That I can verify kindly.
Now there's no hurry. I think now the MCC is in force.
So that's why I was expressing urgency on that. Now there is-
Lordship,
there is-
kindly keep it parted or let it come on Thursday, Lordship.
Thursday will be difficult with you coming up in a short period. I'm not keeping it parted, anyway it will come up.
I'll get that clarification or what has happened. I'll get that.
When do you want?
I need 2-3 days time on Monday. Monday.
8 April.
Friday.
Let
Or
it in 9 please.
or on Friday. Or on Friday, I can only to that extent.
5th.
Interim to be continued, Lordship. Obviously.